Hello, it's 2015. Happy New Year. This is the target year for the Millennium Development Goals, when the international development community will assess progress made against poverty and hunger, education, health, gender equality, and related basic human needs. It is also the year in which the so-called post-2015 agenda will be agreed and the new set of goals, the Sustainable Development Goals, will be established. Consultations with more than 1 million people around the world have revealed that inequality, injustice, indignity, lack of respect for human rights and the rule of law need to feature prominently in the post-2015 agenda. While we now have a lot of experience and have made some progress in the areas of basic human needs and sustainable development in general, we still have a far way to go in bridging the gaps in inequality, justice, human rights, and the rule of law. To this end, I have prepared a new book, The Legal Rights of the Poor, Foundations of Inclusive and Sustainable Prosperity. In the book, I first review what the international community has learned in the fight against poverty. I then describe aspects of the informal and extra-legal sectors of society where more than 80% of the people in the developing world live, do business, and work. The extreme forms of informality and extra-legality are to be found in slums. Brief descriptions of life in two of the largest slums of the world, Dharavi in Bombay, India, and Kibera in Nairobi, Kenya, are included. It is striking to note that more than 4 billion people live in informality and extra-legality beyond the normal rule of law. Of these, nearly 1 billion people live in slums. This is the reality in which the international development community will have to pursue goals related to injustice, indignity, human rights, and the rule of law. The first questions to be answered are likely to be, are these people interested in living under the framework of the rule of law? Will they not be worse off? Do they trust the legal systems of their countries? Will they be able to hold their governments accountable? Is the level of corruption so high that they have no choice but to continue living as they do now? So in Chapter 3, I describe cases in which marginalized people were able to go to the courts and win their rights. In these cases, governments were ordered to meet the rights of the people. It is not easy, but it demonstrates what is possible. I then provide in chapters 4 and 5 a synopsis of the legal empowerment process in which poor people can regain control of the factors governing their livelihoods. This is the agenda which was first articulated by the Commission on Legal Empowerment of the Poor in its landmark report, Making the Law Work for Everyone. In Chapter 4, the 4 pillars of legal rights, access to justice and the rule of law, property rights, labor rights, and business rights are defined. In Chapter 5, the process of making legal empowerment a reality, including the challenges and pitfalls of trying to do this, are described. One of the fundamental issues in this area of work is that of power relations and the role it plays in keeping people poor and marginalized. The reason that empowerment is so difficult is that people who have power never willingly give up power to those who do not have. The poor and marginalized have to take power. So it is not empowerment per se, but a self-empowerment process that must be supported. This would be made much easier if power could be a positive-sum game in which I do not have to lose power for you to gain power. I do not have to be wrong for you to be right. So the elite, from local landlords to big corporate interest, might see that empowerment of the poor is in their own interest. A major conceptual shift from power as a zero-sum game to power as a positive-sum game will, however, be necessary. So in Chapter 6, I describe how this might happen, both from a theoretical as well as a practical standpoint. In the next chapter, I discuss one of the big issues in legal empowerment and legal rights, the legal empowerment of poor women and girls. But the approach I take is not one of classical gender equality work, but rather a consideration of how girls and women might use the framework of human rights and the process of legal empowerment to reach their full potential as they choose to define that. Gender equality might be a first step, but why should women and girls be limited to the potential of men? The book then concludes with an integrated, holistic, and transformative framework based on a nuanced form of the Sustainable Livelihoods Framework. This is offered to the international community as an approach to implementing the post-2015 agenda and to achieve the Sustainable Development Goals which will be agreed this year.